Here in the state of Nevada, you cannot refuse to take a chemical test if you're a suspect for a DUI. We have an implied consent law, which means when you obtain your license, you're impliedly giving the state the authority to determine whether or not you're under the influence of alcohol or a drug. And the drug doesn't just have to be a controlled drug. It could be a prescription drug, anything that impairs your ability to drive. Now, if you get pulled over, prior to administering an evidentiary test, a law enforcement officer is likely to ask you to submit to what's called a preliminary breath test, and that's something that's done in the field. If you refuse to submit to the preliminary breath test, you're looking at a 90-day suspension. If you refuse to submit to an evidentiary test, which would be breath, blood, or urine, you're looking at a 1-year license suspension if ultimately you're convicted of a DUI. The law here in Nevada is a little bit tricky when it comes to the right to choose what type of evidentiary test you want to take if you're stopped for a DUI investigation. Technically, you have the right to choose breath or blood. One advantage of taking the blood test is that if you feel that you're not under the influence, it preserves a sample of your blood that can then be retested at a later date. If you do a breath test, no sample is preserved, so you can't seek a retesting. However, if you're under the influence of something other than alcohol, you may choose to take a breath test because a breath test is only going to turn up alcohol. The law is a little tricky here because if the officer suspects that you were under the influence of something other than alcohol, then he or she may then require you to take a blood test, but they have to be able to articulate a suspicion that you're under the influence of something other than alcohol. So these are factors which you might consider when deciding whether to take a breath or a blood test. Don't just assume that if you were stopped for a DUI investigation and you refuse to comply with the testing, that automatically that means you're going to get convicted. Some people have legitimate reasons as to why they didn't cooperate with law enforcement. They may say that the officer was overly rude or aggressive and that their decision not to comply with the test taking had nothing to do with whether or not they were under the influence, but was in fact related to some other circumstance, which may, if the case were to get litigated, be justifiable. So it's important if you're charged with a refusal that you obtain counsel, that you discuss the factors that gave rise to the refusal with your attorney. And what's really important to know is that if you win the underlying case, then you are absolved from any penalties that would be associated with refusing to comply.